Hello, it's Philip Taylor speaking from Richmond Green Chambers. I'm looking at a book this morning from Edward Elgar Publishing Limited. It's got the title Methods of Comparative Law. It's been edited by Pier, Giuseppe, Monateri, if I've pronounced the name correctly. My apologies if I haven't. We've given it the title on the web, Comparative Law, Exploring a Continually Evolving Field of Inquiry. And we'll go into some detail in a minute about it. Let me show the book first. There's the front cover, the spine, and then there's the little bit of blurb on the back. You've got some nice dusty law reports on the front, just to be in keeping with everything. There's a nice little index which you've got. It's 300 odd pages long. The actual book itself, let's just go through it. There you see how it's structured. You've got footnotes at the bottom, lots of academic stuff there. That's numbering in that particular chapter. I think it's quite helpful to have a certain amount of numbering. It's not paragraph numbering in that sense, but it's certainly each of the chapters has got a fairly substantial structure to it. Some of the footnotes are frankly a little bit long, but that's the way it is actually quite often with these publications. There's a useful introduction which is well worth reading at the front, and then you can see the list, very substantial list of contributors, just to give you a flavour of the large number of people involved. Then of course right at the front you've got the actual contents itself there and there. It's only a light book, but it's another very useful contribution to the academic debate. It's been recently published by Elgar, and it presents a collection of some of the most significant exploratory and definitive treatises on the often complex and wide-ranging area of comparative law. Within one convenient volume, therefore, what it's doing is bringing together the work of no less than 19 academics and scholars from top universities and law faculties worldwide. The depth and breadth of erudition on the part of each contributor is nothing if not impressive. Numerous avenues are explored down the pathways of, for example, the history of law, the philosophy of law, jurisprudence, and the interplay and overlap between these disciplines and others, including economics in particular. Here's just one example of these intriguing excursions down a particular pathway of inquiry, and we quote, "In recent years, a new generation of literature developed at the interface of law, economics and public choice theory provides an alternative hypothesis regarding the evolution of the common law." Interesting point. Agree with it or not, the operative word here, we believe, is interface, and as the title indicates, we're talking here about interdisciplinary and multidisciplinary research. If this sounds a little abstruse, it is nonetheless intriguing and has a number of practical applications in law, certainly as well as economics and public policy. And as the editor explains, the structure of the book includes the sequence of chapters as well as the selection of individual essays, being designed to focus on the evolving scope and shape of legal comparativism. The result, he says, is an accessible manual from which scholars and students and practitioners can benefit. And the answer is yes, they can. It's very much part of the handbook series from Elgar, and it will no doubt be of interest, I think, to the worldwide academic community. So thank you to all concerned for an excellent publication. Bye-bye.